He responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but.
Okay, I'm going to get it for you because
Okay.
I don't want there to be any assumption. As soon as we have it. Let me show you. This is.
So, is that what you're?
I'm going to show you if I might approach. I made reference to an email that Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:25 a.m.
Yeah, I see it, the email, yes.
So that's the email that you received. Along with it, obviously the attachment, which is referenced.
Yes.
And then, did you respond to that email within the text message that I've just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay. I'm going to mark this as another exhibit for Your Honor to look at. Since you wrote my tone, can I have a seat? Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Yeah. What's the court's rule to ask or not?
We'll take it case by case. I think he's doing all right, so we need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
Was your response to the email of Ms. Merchant, which is on page 1, is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay,
privileged.
sustained. Stay down. Next question.
Do you know whether or not your attorney shared privileged information with the district attorney's office?
No, I don't know what my attorney shared or didn't share. I don't know if they even met.
Last question, have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee sharing partnership, pseudo partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I wanted to leave and go out on my own. Yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I don't want to try not to get into the specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Ms. Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have
Wait,
anything to do with his conduct?
hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed. And so we dissolved, I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
If you define misconduct, I'm telling you, we had a disagreement and
Just tell me what the disagreement was then.
the disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged. Why is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Ms. Willis.
As it a connection to Ms. Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
I'm not sure what this correct means under that. You kind of got lost on it.
We asked the
It
question.
did not relate to your representation.
It did relate to my representation.
In the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I'll have to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I will have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was, I don't know.
Continued representing him in connection with the divorce case after you had the separation that you've made reference to.
And he continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Ms. Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Sada, I think we've.
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So I can't get an answer to whether he possesses information which is inconsistent
No.
without getting into the information itself.
I think the issue would be that we've already gotten an answer on that. Now we're asking the same question again. Ms. Merchant asked some variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
Okay.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Unless it's for impeachment at this point. But Mr. Sada, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
So you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're
Reserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was attained and the extent of it in the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question to court before I sit down is if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credible determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do
Okay.
with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadout, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule
Other
this
than
for
the one I
argument.
gave you,
The Coca-Cola
1930,
one,
the 1935 case.
the Atlanta Bottling Company. I don't think I went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court. But we can flesh that out in our research.
I appreciate it. Thank you.
Okay. Mr. Stockton,
No question, Judge.
Mr. Durham,
No question, John.
Mr. McDougald,
No question, Your Honor.
Mr. Rice,
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel on him for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on?
Say that again.
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well.
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Judge, I would ask the court to take judicial notice of that.
for what relevance?
Judge, I think it does go directly to the crime fraud exception. Because before we draw objection, because if Mr. Wade was providing information to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Let me pause you there. Isn't adultery as a statute just on its face been found unconstitutional? You
It
can't
is.
actually charge anyone with adultery anymore.
it is still current. In the
Then it
state.
can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense. Therefore, the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it'll be speculation.
Right now, sitting here,
Mhm.
you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office?
Your Honor,
And when did you open the file on Mr. Wade?
Your Honor, I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship. So I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we could spend too much time on this.
No,
so
okay.
We'll see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it? Yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of a practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. you were doing it pro bono for a friend, weren't you?
Yeah, I'm going to ask and answer.
All right. So I'm going to sustain that, Mr. Gillen. I think the law is clear that money doesn't even have to change hands for that relationship. And I'm making a finding based on the evidence that's already been presented, namely the fact that he signed pleadings, attended depositions on Mr. Wade's behalf, that attorney-client relationship did exist.
Well,
At some
okay,
point.
I was just laying the foundation to the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay.
and-
If the dispute is just when it occurred, you can try to hone in on that. But the questions I've heard so far are more from you were never paid ever. It's from a overall angle.
Well, from 2017 until November of 2021, you didn't receive $1 from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we or are we friends? I mean, we were friends at the time. Yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct? Correct?
If that happens in your small firm, yes, yes.
Well, that doesn't happen, or did it happen in your small firm?
Again, the witness has been asked very specific questions about conversations about socialization, and we've gone on through it, so I think this is asking answer.
All right. I'll let him answer this one question. Overruled.
Repeat the question.
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
I assume
Objection, going back into the privileged communication.
Not yet, but it might.
I assume, yes, we talked about sports. We talked about, sports a whole lot.
You talked about life and about what was going on in your life and what was going on in his life, right? Right?
Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
Again, I'm going to object.
Yeah. All right. Sustain. Next question, Mr. Gillen.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life that had nothing to do with him asking you legal advice?
Objection, be more specific.
I think he's just asked whether he socializes outside of legal advice. So I think you can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing, the social life. Did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right. So that'll be sustained on privilege.
Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out a legal advice, not talking about something that might be personal or confidential. And that's the distinction that I would draw.
I think that's a accurate legal point. However, I think the witness has already been questioned and testified on this point.
Thank
So next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussion, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we,
Objection, he's asking about interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered under attorney-client law.
Mr. Gillen?
Well, I don't think it's attorney-client. Did they meet together? And when the interrogatory answers were filed, did he file them, and did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change it a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content.
Objection.
You had all of that knowledge and
Question.
information. I'm sorry, let me get my question out
That's what I
before
was trying to
he
say.
objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's, the follow-up question to that is going to be incorporating knowledge learned during communication. So I'll
Oh,
just
no,
say-
I'm not going to have a follow-up question. I just want to know whether, is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay,
It's all
in which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay, I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to
Well,
Mr. Wade.
it gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant, now.
So what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
Well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered under privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block public the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, the claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What
Okay.
did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship existed prior to November the 1st, 2021, and started in 2019 or 2020. If he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that. Therefore, I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll sustain that objection.
All right. Well, thank you, Your Honor. That's all I had.
Okay. Thank you, Mr. Gill.
Thank you.
Mr. Kacherov, are you still with us? Anyone on behalf of Mr. Floyd still joining us? All right, moving on. Mr. Cromwell.
Two brief questions, Your Honor. I think everybody's exhausted with this line of question, right?
We're going, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the
can you give
file.
Was it sometime in 2023?
No, it would have probably been, well, 2023. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of, it wasn't, I don't have the accurate date, but it wasn't when I left, and it wasn't.
Make it easier for
Okay,
you.
all right.
You were not his divorce lawyer at the time the interrogatory responses were filed in May of 2023. Is that
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
Okay. So, and if they're still open, that means he's still a married man.
Yes, that's correct.
If the fact that in a pleading, there is a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
I guess you have to ask the judge that's handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right. Thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor.
Sorry.
I'm going to have a minute. My cross-examination might be a long one. So we can go for an hour and a half. I have just a 5-minute break.
Sure. All right, we'll be back in 5.